verdict is out. The highest court in the land has ruled that President Museveni will not be barred by the 75-year age limit, and so he can stand again for presidency. In the same ruling, MPs were denied the chance to extend their term from 5 to 7 years. So what are the legal and political implications of this ruling? How does it affect Uganda's jurisprudence? How does it shape politics as we draw closer to 2021? Can even the higher court of the Ugandan citizens decide otherwise when the matter is eventually put to them through an election? On the Spotlight, we will seek answers to these questions and more with a panel of lawyers and political analysts. On my panel this evening, I have two lawyers. Sarah Birete from the Center for Constitutional Governance. Thank you very much for honoring our invitation.
You're welcome.
We have Elson Karuhanga, who's also a lawyer. Thank you very much for coming.
Thank you.
And Mr. Mwambutsa Ndebesa, political analyst. Thank you for honoring our invitation, sir.
Thank you, and good evening, viewers.
And a warm welcome to all of you. We really had, what a long day. Most of Ugandans who were interested in this verdict were glued on TV from 10 a.m. up to 6 p.m. It was somebody liking it like watching the World Cup finals and somebody's taking spot kicks in a slow motion and you do not know which team is going to win or what. At one point, some people were saying, oh, it is 3-2. I'm like, but at the end of the day, it ended the way it did. But let me begin with you from the Center for Constitutional Governance, Sarah. Were there any surprises regarding how the Justice of the Supreme Court ruled today from your point of view?
Not at all. And I think the justices of the Supreme Court chose the best time, Easter week, for the ruling final nail in constitutional governance and constitutionalism in Uganda. The Easter week is the week Jesus was betrayed. So I think there couldn't have been any better timing. No, they knew.
I didn't see that imagery. Okay.
They knew they were going to betray the spirit of constitutionalism in this country. They knew they were going to betray Ugandans because our preamble is very clear. It reminds us of our political and constitutional turbulence. It reminds us that for 56 years of independence, we have failed to achieve a peaceful transfer of power in this country. It reminds us that the spirit of constitutionalism in paragraph 3 of the preamble is to have a durable and popular constitution.
Let me take this to Elson Karuhanga, and I want to remind you the words just been spoken by Sarah Birete here, bringing the imagery of the Bible, that you know that the Friday, which is like tomorrow, that to them, those who are opposed to this is the real betrayal, like it was depicted or shown in the Bible.
Well, I don't want to respond to the imagery of betrayal. I don't think it is correct. I understand, of course, when people are unhappy with the decisions of the court. Because people who are on one side, when they lose, they usually think it is like Judas, it is like betrayal, it is like crucifixion. When they win, they think it is redemption, they think it is resurrection. So
is that how also you take it?
No.
So you're such a different person?
No, I'm not such a different person, but because I practice law in this country, I know that there comes a time when you win some cases, when you lose some cases, when you convince some judges, and when you don't convince some judges. Today, for example, there are people who are praising the 3 judges who dissented. 2 of those judges, only 2 years ago, were part of a panel of 9 judges that upheld the election of President Museveni. We heard then that they were Judas, that they were wrong. The thing is that people only want to agree with judges when judges agree with them. So for many people, it's like working out a mathematical formula. They start with the answer, then they want to do the working later. But I think in this particular case, the judgment does not represent a betrayal. In fact, the judgment of the Supreme Court and the jurisprudence that is coming out of the Supreme Court with regard to very big issues in the amendment of our Constitution represents the continuous constitutional development of Uganda. The court is operating, I once pointed out at another place, that the court is operating almost like the country is in a form of a constitutional laboratory, where the duty of the court is to mix the different ingredients of issues before them and produce jurisprudence that will last.
There are sometimes accidents in the laboratories, numerous.
Yes.
And sometimes,
Yes,
sometimes they use guinea pigs and all this kind of stuff. And perhaps are we, the people of Uganda, being used as guinea pigs in the laboratory experiment for Uganda?
In defense of the court never brings the dispute to it. There are people who go to the court. When they go to the court, they should go with the knowledge that it is very likely that they may win, and it's also very likely that they may lose. And winning or losing does not represent betrayal. I think that the reasoning of the majority and even of the dissenters that at least we had today was grounded in law, was logical, was considered. And you see, the idea that people should always agree with you is very dangerous. I think was it John Locke or someone who said that if all of mankind was on one side and one individual was on the other side, it would be wrong for all of mankind to try and change his opinion, just like it would be wrong for that one individual to try and change the opinion of all of mankind. For us, from where we sit, as legal professionals, we come to the position where we know that when it comes to judges and their judgments, it is not so much the individual or before the court, but it is the argument. If we are to measure these judges and criticize them on their arguments and not on our prejudices, I think it would be better.
Okay. It's not the individual, it's the argument. But how about the whole, there's something to go beyond the argument, to go logic and all kind of stuff. But let me bring this to you, Mr. Mwambutsa. Yeah, but sometimes you can win the argument, not necessarily that you're right, but you can have the power of persuasion because it's just persuasion, and persuasion may not necessarily be right.
No, I'm not talking about persuasion. I'm talking about the court does not deal with prejudice. It deals with the logic that you have brought before it. But I can...
Yes, Professor Mwambutsa Ndebesa, I just want to know where you stand on this issue and how you saw them today when the verdict was being given, or whether you too, just like Sarah, were not surprised.
Well, I'm seated between the two lawyers. I'm not a lawyer, and I'm not going to use the law logic. But a while ago, you and my neighbor here were talking about jurisprudence. You want to hazard the idea there and see whether I will be corrected, because that's not my area. But when the lawyers or the judges, when the judges are making a judgment, in law, don't they also use jurisprudence if you want? That's the theory of law or the philosophy of law or the morality of law. And as the letter here said, the Constitution, the preamble, the first statement says that aware of our constitutional and political instability in Uganda, the history of that instability, we do the following. We are the judges. Is there something like judicial consciousness or conscience for that matter? Were they aware, or did they consider, or were they informed by the effect of the amendment of this article to provide for no terms in Uganda or in Africa, considering that it has brought about political instability even among our neighbors? You are talking about Congo, talking about Burundi, even in other countries, Malawi, Sudan. Did they consider that? Because I heard the judges talking about quoting the law in Australia, in New Zealand, in wherever. What about quoting the experiences of other countries within the region? Do they use that conscience? Secondly, do they use the jurisprudence to say that what we are judging, is it for the greater good of society? Because this is public law. At least that's what I think. It's not private law. It's public law. It is about the order of society, bringing order to society. Do they think that by upholding the amendment, it will bring more of order or disorder? So when there is judgment, when judgment is being done, these lawyers can help us. Do they have that conscience? Do they have that morality, or do they have that in law that in Uganda or in Africa, Uganda, which is a developing country, it is not yet a nation state, it is breeding nationhood. does it mean in their conscience, in their thinking, in their jurisprudence, if you want, because law is also about building a nation, isn't it? Now, do they think that by upholding the constitutional amendment to have no term limits is a way, age limit, sorry, is one way of building a nation, of building a national consensus? Does it look like amending this constitution has brought about or will bring about national national consensus? If not, then how should they have judged? So I don't know, maybe lawyers or judges just simply argue law, but in my opinion, when you go to jurisprudence, they should have considered where the country has come from, where it is going, and looked at this article and see whether it is the bedrock or one way of building a nation, or changing it is one way of building a nation. So I don't know when they are, what informs them in the wider perspective of making their judgment.
Sarah, how costly do you think would it have been if the judges had ruled against had ruled otherwise to the NRM government or even to President Museveni?
Going by the precedent that was set, the military siege on Parliament, maybe the military could have attacked court. I think that's the worst, because it has happened. The military attacked Parliament during this very process. So maybe the worst that could have happened is the military attack.
So you think the cost could just be on them, maybe?
Yes,
maybe
and the deployment was visible. So maybe the military could have attacked court. But could that have scared the judges? I don't think so. I don't think so.
So you're coming from a prism that judges were scared?
Judges were scared.
No, we are saying what worst could have happened. Because if you look at the judgments, and if you read between the lines, there was consensus that procedurally everything that could have gone wrong in a constitutional amendment went wrong.
Are you suggesting that the conclusion was at variance with the body?
Of course, some judgments are not matching up.
Everything that could have gone wrong went
wrong
they were victim
in
of
this
Murphy's
constitutional
law.
amendment. Everything that could have gone wrong, the beating of Parliament, the beating of people during consultations, the money, the bribing, anything that could have gone wrong in a legislative process went wrong in this constitutional amendment.
Were we victims of Murphy's law?
That's the argument that was defeated in court. But let me first of all come to the idea that supposing they had lost, the military probably would have attacked court. The beauty about this case is that this is a case in which the Chief of Defense Forces was summoned to those courts and cross-examined and took an oath and subjected himself to the jurisdiction of the court.
What is that supposed to mean?
No. So I think the idea that somehow the judges were scared of the army is very wrong. We saw in this case, in the lower court, the summoning of the Chief of Defense Forces. We saw the summoning of I think an assistant inspector of police. We saw the summoning. I think if you can allow me to finish and respond to what was said, because so that the interruptions are evenly balanced. As you see, I am representing one side, well, that isn't agreeing. So if I could just make the point, then you could come in, if you don't mind. The point I'm making is, I don't think it's fair to say that the judges were scared. These are the judges who summoned the military commander to court to explain his command and subjected the command of the military to the jurisdiction and jurisprudence of the court. Secondly, I've heard a lot about the preamble of the Constitution, which says, "We the people of Uganda, knowing our constitutional history." That very issue of the preamble was an issue in this matter. Both in the lower court, the Constitutional Court, and in the Supreme Court. An issue arose, a new issue actually in our constitutional dispensation, what was called the basic character doctrine, basic structure doctrine of the Constitution. So a lot of these issues were brought. Now it's okay to look at the decision of a person and disagree with it. But I think what is not okay is to cast aspersions on the character of people whose views are different from yours. I take it I think that they are scared. The idea that they are scared. No. The idea
Patrick,
that they are traitors. The idea that they are scared. The idea that they are Judas. The idea just because someone is thinking differently from you. I, for example, may not have agreed with some of the judgments of the judges. But and even some of the arguments of the panelists. But I think I very much respect that those views are held honestly, and I think the judges should be accorded the same
Patrick, I need to correct
courtesy.
this misrepresentation. The question was, what could have gone wrong?
Yes.
And I answered starting with maybe. That is simple English. I referred to something that
Apologies.
happened.
And there was
I said yes.
I apologize to you for
and there's
misunderstanding your simple English.
a precedent also.
There is a precedent. Parliament was attacked by the military. So I said maybe.
Well,
That could have happened. Because it has happened before. So that misrepresentation is not necessary.
my apologies if I misrepresented you. But the point which I wanted to make, the general point which I wanted to make was that even in response to Professor, the argument that do the judges consider what happens in other jurisdictions? I think it's very important to understand the role of the court. The court goes into the dispute as an umpire. You see, the political dispensation of this country, the people who decide issues of policy, issues of what Professor was calling jurisprudence, which is really politics, are people who are elected.
Constitutional politics definitely is there.
Yes.
You can't say there is no
Yes,
constitutional politics.
I agree there's constitutional
And
politics.
I can see
And in the role of constitutional
in the whole of
politics,
this process, there was constitutional politics.
yes, and in the
Yes.
role of constitutional politics,
Yes.
the judge stands as an umpire, as an arbitrator
And
between
plays his politics.
between two different sides.
Okay.
The real political questions, it is a mistake to think that political questions, issues that should be resolved politically, are matters that you're going to resolve judicially. The judiciary is not a constituent assembly in permanent sitting. The judiciary is not the second chamber of parliament. The judiciary is not a legislative body. The judiciary is a judicial organ. It interprets written statutes. That constitution we have is a written document. They look at what is written in it. It is the starting point. The starting point is not what happens in Congo. What happens in Congo is a starting point of a political discussion. It is a mistake to expect judges to enter a political arena and resolve
the same constitution, Mr. Karuhanga, also looks at the history of Uganda, the political history ofUganda.
the preamble of the
Yeah,
constitution.
the preamble, yes. So,
And
so
no
there's
doubt-
a reason why.
and no
There's a
doubt-
reason why it looks at it brings out the politics under tumultuous times.
And no doubt, the Constitution is a result of a consultative process that says, considering our history, this is what we have agreed shall govern us. The judges, yes, have to consider.
So
all-
are they not supposed to
the judges
consider?
have to consider. They have to, and in fact, they did. They have to, and in fact, they did consider all that. But what we need to understand is that if we are going to look at the resolution of political disputes,
So in other words, the Constitution also is telling us that always be aware of the political ramifications of where we have come from, and that's why it is put
but
in
that
the
does
preamble.
not mean you should disregard the text.
So
That does not mean you should
there is a reason.
If the
There's a reason why they give you that preamble.
If the Constitution says,
There's no reason why they give you that preamble.
if the Constitution says that the results of, for example, a presidential election shall be declared in 2 days, you cannot argue against that provision using the preamble, using the history, using what happened in Congo. There's a text. The point I'm making is not that the judges shouldn't go there, but you must always remember that
No. In this argument, what I wanted to find out from you, I suppose it is important always to look back at that preamble, because that preamble gives you a foundation of where we are.
But
even though they are not going to use the preamble to make their judgments, but it's important always to give them the locus.
And they did look at the preamble.
Okay.
But the
Can I come in?
Yes.
Somewhere, somehow, in the private conversations, you could find people predicting how one of the judges or some of the judges would judge. That is an implication that there is a politics behind it. That they know that one has this side, the other one has this side, before even the law was controversial.
So if I can
So there
understand
is
you,
the
Professor,
politics
you are
in
saying
it.
that those who ruled against,
No, but I think you should be given time to talk.
are you saying?
Can
No,
you
no,
please
no,
allow me?
please.
Please,
Before,
my apologies, my apologies. I just wanted a
No,
clarification.
no. Let him
Before
submit
we-
first.
Okay, one at a
But
time.
my
We go
apologies.
into some controversies which I don't shy away from.
Yes, I know. Because I want you to clarify
Okay,
for me, just.
please.
Yes.
What I was saying is that I don't think that the judges should disregard, for example, the norms of society. They are legal norms, but they are also norms of society. And I thought that law is about the aspirations of the people. So I do not know. Anyway, I'm not a lawyer. I don't know the judgments, how they are made. But I don't know whether the aspirations of the people in Uganda is that they should be ruled by somebody who is above 80 years. Incidentally, I think the petitioners made a mistake, and I agree with the judges, the little which I had. Those petitioners made a blunder to say that the president of Uganda should be only 75 years. No. I was in CA as a researcher, so I know the background of everything. It says that the date, the year of 75 is about standing.
At nomination.
At nomination. In other words, theoretically, according to Article 102B, the previous one, is it 2 or B or whatever, you could theoretically stand when you are 74 and 11 months, and you could practically be in office when you are 79 and 11 months. Now, the Constitution, I know the spirit of the Constitution, of that article. The spirit was to ensure that at least the highest the president of Uganda should be in office would be 80 years. Sincerely speaking, are the aspirations of Uganda for a president to the fountain of honor, the one who holds the destiny of this country, to be above 80 years? You mean Ugandans are aspiring to have a Mugabe, to have a Bouteflika of Algeria, or Hajib Bojiba of Tunisia, fellows who were removed from office because of seniority? Because Article 102B was about the president, the maximum being 80 years or 79 and 11 months. To me, the aspirations of Ugandans were to be that. Okay. Now, I don't know whether judges, when they are making judgment, they just consider only the letter of the law without the spirit of the law. And the spirit of the law, as per CA, was to ensure that Uganda would not have a senile person in the office of the president holding the destiny of this country and its people in the hands of somebody above 80 years, which naturally is an age where somebody should, by all intents and purposes, be retiring.
In fact, even the incumbent president himself disqualified himself, saying, at that age, you're really physically...
And it was you who was interviewing him,
and I believed him because he understands the job. So I'm more inclined to believe him than anybody else on this table.
For him, he was even talking about 75. The Constitution is talking about 79.
Court took note of irregularities in passing the amendment, but still didn't rule against the age limit. Is this not troublesome as we move forward? Because they say, yes, this and this was not right, but...
You know, there's a tendency, if when it comes to political questions, there's a tendency for vagueness. It is not new. You can read all the Supreme Court verdicts in election petitions. They always make findings and then shy away from making decisions in relation to the findings. So if there are irregularities, and like I said before, anything that could go wrong in the enactment of a law went wrong in Constitution Amendment, Bill number 2, Constitution Amendment of 2017. Anything that could go wrong went wrong. So if the judges, in their wisdom, and in exercising their powers to check the excesses of Parliament, did not find it necessary that these things could have been corrected, I think then there's a problem for constitutionalism in this country, because constitutionalism is not a presence of a mere document of a constitution. It is the spirit behind the constitution. It is the day-to-day reference of the people, the stakeholders, to the constitution and its contents. It is the key stakeholders recognizing the importance of that constitution. So if all these are lacking, and then you have people saying it is okay, so long as it benefits those who are in the regime, and then you have them versus this group in a supreme law of the land, I think there's a problem and people should be worried. Before
we take a break, Mr. Mambutsa, is Uganda getting more polarized now?
I don't see a consensus. And Uganda and generally Africa in this new wave of so-called democratization, one of the polarizing factors in the governance and democracy and constitutionalism in the whole of Africa, by the way, is the question of term limits. It is one of the most polarizing, and I can see it also polarizing Uganda, and yet Uganda should be building the nation and avoiding polarization, and as much as possible trying to create consensus so that we can have nation building. So this article, I am surprised also that the lawyers, the judges did not see that this article actually is one of those articles when it touched shakes the whole constitution. Because after all, in that very article itself, 102, the other, it is A, B, and C. A is also talking about limits. I think it is talking about you must be a citizen by birth. And that is already discriminating, like they claim. And the Article 102C is also talking about qualifications of education. All of the three in that article, A, B, and C, we are talking about limitations. But the framers, the framers, no, I mean the amenders of the Constitution, if I can use that English, only looked at B and said that we need to have a liberal constitution that is not rigid, that does not put limitations. But I don't know where their eyes were looking, because A of the same 102 is talking about limitations. Why can't somebody who was born in Uganda or whose parents were not in Uganda in 1958 and who is not a citizen by birth, why wouldn't he also be a president of Uganda? And why wouldn't somebody who completed Senior 4 but understands issues in Uganda maybe also be a president in Uganda? So if you were about limitations, removing limitations in the constitution and rigidities, why did you handle 102B and not A and not C? And finally, if you touch 102B, in my opinion, I'm not a lawyer, then you have touched A and you have touched B of the same article, by the way. Therefore, anybody can now come up in law and challenge A and B, if we and then use precedents that since the other people said that 102B should be removed because it is discriminatory and limiting, then A and B should equally go. In other words, by removing 102B, you have already shaken the whole basis of the Constitution, including that article.
Very quickly, Alison, before we go for
the Constitution is not amended by reflex action. There are provisions of the Constitution. If you want to amend A, there is a way you amend it. If you want to amend C, there is a way you amend it. If you want to amend B, there is a way you amend it. You cannot say that because I have amended B, then someone can petition that therefore you amend A. The amendment of A or B or C is something that can be done in accordance with the Constitution. What I find very interesting, I mean, I'm very impressed with the argument of 80 years, I'll be honest. The idea of who shall determine, the idea of who shall rule the people of Uganda is a question that the Constitution left, not for the judges, but for the people. And that is why even if you're 80, you can, if the people want an 80-year-old, they should, the Constitution,
how is it exercised?
It's by the people at a ballot.
Free and fair regular elections.
Yes,
it's very clear. So don't just quote the Constitution conveniently.
I'm not quoting the Constitution.
Alison.
But what I want to say before we go for the break, the term limits. The very interesting thing about the term limits is that the Constitution Amendment Bill actually introduced term limits. Nandala Mafabi amended the bill that was put on the floor and introduced term limits. The petitioners petition not just against age limits,
because it was
but
not
also
done in a proper way.
Against term limits. So
It was a procedural question.
Elson, Sarah, and Mwambutsa, we're going to take a
Sarah,
break.
allow me to finish
When
my
we come back,
sentences.
let's find out whether the higher court of the people of Uganda, when it comes to 2021, can decide
finish my
otherwise. We'll be right
sentences.
back. Welcome back. You're watching On the Spot. My name is Patrick Amara. My guests tonight are Sarah Birete, Mwambutsa Ndebesa, and Elson Karuhanga. Maybe as we discuss this ruling that was just given to us a few hours ago. Can the even higher court of the people of Uganda decide otherwise if the matter is put before them in 2021 in an election, Sarah?
You see, the Constitution provides...
I'm assuming somebody beyond 75 is going to seek election.
Yes, the Constitution in Article 1 provides that power belongs to the people who shall exercise it in accordance with the Constitution. And among the conditions through which people exercise their power is the presence of free and fair, credible elections in a regular manner. We have had 3 election petitions under President Museveni's regime in 2001, 2006, and 2016. In all these election petitions, the Supreme Court has unanimously agreed that we don't have free and fair elections in this country. If you go by the recommendations of the Supreme Court, the very court that has now removed the last safeguard for people to achieve peaceful handover of power, made 10 recommendations. They are all electoral reforms. And that was in recognition of the fact that this country has been incapable of organizing or presiding over free and fair elections. So given that background, the people cannot hold a final verdict because they have been denied of an opportunity to exercise their free will on who governs them. So my answer is no.
Okay, let me also put another question, because you work at the Center for Constitutional Governance. And constitutional governance is what you want to see happen. Do we still have constitutional governance?
Or a center?
No, the center
exists.
I suppose it is there.
It exists at Prot 14 Ministers Village in Itinda. The center exists. Do we have constitutional governance? The question is neither here nor there. We have a constitution, but we do not have constitutionalism in this country. And the leaders are intentionally against promoting constitutionalism. It starts with Parliament. Under Article 75, the main duty of Parliament is to promote constitutional governance in this country. But how have they promoted constitutional governance over time? The other main duty is to safeguard the Constitution. So if you scored them against those key constitutional functions, how would they fare? Then we go to the courts that are supposed to check the excesses of Parliament. How do they fare? If you go to the people, given the levels of ignorance, largely the Constitution in Uganda is a lawyer's document. We are struggling with educating people about the Constitution. Article 4 mandates the Human Rights Commission and other agencies to teach the Constitution, to translate it into local languages, and all the other good things that can happen to promote the understanding of the Constitution. But do they happen? Instead, you hear references of leaders saying, do not open the eyes of the people about the Constitution. So the Constitution is a hidden tool for lawyers to exploit for their selfish benefits.
So also, how do you respond to that? That the Constitution commands, I suppose, the government to translate the Constitution maybe in all the other languages, or at least major languages, so that people can understand this document, the supreme law of the land. But that has not been done. Isn't that a problem?
Chipping in, just even that those who know English, and there is one which is in English, have they read it? He can continue.
I concur.
Yeah, you give it to them.
So is it about the people?
By the way, for your information, this constitution was translated in the four or five major local languages
with small
in
copies,
Uganda.
With small copies by Office of Prime Minister.
No, before the Office of the Prime Minister, there is an office which translated them way back in the 1990s. So,
and what happened?
But even those in English, as I have just said, how many have read the Constitution and internalized it and applied it? So the question is not the translating in local languages. The question is civic education, which can take different forms. But anyway.
But what would be the motive? Looking at the land farers and how they think around with the Constitution, what would be the motive of an ordinary person?
If I can come in here, I must say, I wanted to say that actually such a things like this constitutional amendment and the debate therein is an indictment to liberal democracy in Africa. You asked Mr. Kamara, you asked Birete as to whether if they take it to the court of the public, they will rule this way or the other way. Let me put it this way using the examples of what has happened in Africa. Bashir, just 2015, got 94%. Where has it gone? Does elections reflect the will of the people? Bouteflika got 81% and he has been removed also through that means. Bojiba of Tunisia got that. Mubarak got that. Saddam Hussein got 99. Where does the 99 all of a sudden go when everybody is in uprising against you? That is an indictment on liberal democracy in Africa. Elections per se, voting per se, does not reflect the will of the people.
I think this ruling is fine.
But the idea that the will of the people at voting and elections should be replaced by the will of judges in petitions is something that I think doesn't also augur well for liberal democracy.
There should be a good combination.
We are not saying...
yes, and for your information, I don't know, you are a lawyer, I'm not, but I am told that judges also make law.
Yes.
And therefore, the judges could stand on their ground and make law for the good of this country by making a decision that will serve the greater good of society rather than upholding a law.
He's going to tell you this is the law they have made.
Listen,
no.
A law that serves...
No. This is a point of departure. So what he's saying is that the judges
can make law.
Should sit there and dictate the law. The judges should be the upper chamber of parliament. The judges should be the final electoral college. The judges should be a constituent assembly in a permanent session.
That's not what I said. Can I tell you what I said?
No, you are saying judges can make law.
Yes.
Law is made by specific organs of lawmakers. Judges are law interpreters. And the very good thing is that the judges know that is a very dangerous precedent they would be setting. Because I can tell you that you will not like a law that comes from a particular judge.
How come?
The whole idea, and this is the point, the whole idea of liberal democracy, as you've called it, is that as much as possible, the lawmaker should one day, at a particular point in time, go back to the people who sent him to rate him. My sister Sarah asked about if you rate these MPs, how are they performing? The rate of MPs will come. They will go back. Whoever voted on whatever they voted will go back to the people who sent him. The judge is not going back anywhere. They are going back home. And they are going to remain sitting there. So what you don't want is an unaccountable power. Judicial power can end up being unaccountable. That is why the judges are very, very careful that their role and their extent has been limited by law. It would be a great travesty if the person who is supposed to interpret the law has the law limiting him and says the law shall not limit me, but it shall limit you. Now, let's talk about elections in Uganda, because there's talk about elections, liberal democracy.
Elson, if I could ask you to comment on Article 146. Judicial power is derived from the people. It must be exercised in accordance with
Article 126.
Yes,
Clause
with the
1.
views, yes.
Not 146.
Yes, wishes, aspirations, and values of the people. Yes. What's your take on that when you say the judges?
Yes,
people,
the judicial power,
no
you see, the constitutional power vests 3 arms of government. But the Constitution also provides that the people are the ultimate authority. This is why when you go to your basic structure, your basic thing in the Constitution, you cannot tell the people, Parliament cannot say, let the people choose someone. And then the judges say, no, let us limit the choice that will go before the people. There are the judges acting in accordance with the people. Remember also that the real chamber of people's voices are those who they elect, those who they select, and those who they deselect. Now, we want to talk about liberal democracy. We want to talk about liberal democracy and constitutional history. One of the biggest challenges, I am a lawyer, I agree, and I am not a...
A small one after that.
Maybe you mean physically, but maybe small in every other sense. But you see, Professor is a political, social historian and political analyst. So I'm not that. But what I can tell you is that the law, you see, so there are two different views. Should law be what we sit on, or should politics be what we sit
Can
on?
I come in quickly, Mr. Moderator?
You know,
I want to come in.
sometimes something can be lawful, but actually more or less immoral. We have seen some laws, for example, in South Africa.
And something can be moral and unlawful.
For example, the apartheid was illegal and something that is acceptable and is in the law books of South Africa, but it was something that was abominable.
But apartheid, the purpose of apartheid was to lock out the entire population.
Yeah, but here even some he was telling you some people
So-
are going to feel
so-
discriminated against or
So
locked out.
that's the colonial law. For example, it was illegal for the kings here
But for
to resist the colonialists.
But around
They were arrested and sent to Seychelles
around that time,
for defending their
around that
independence.
time, and the judge would be using the law.
Can I chip in here?
Yes.
Yes.
I wanted to say, and I stand to be corrected by the lawyers, that Uganda
We shall correct you. Don't worry.
Uganda is under the jurisprudence of the common law?
Yes.
And the common law does not necessarily have to follow the law legislated in parliament.
No.
It might also follow the customs and the norms of the people. And I saw the judges here today, I had them using law of precedent elsewhere.
Yes.
Not they were using parliament, the rules of procedures in parliament and the constitution of Uganda, but also precedent
They were
elsewhere.
informed by the decisions
They
of
were
courts,
informed by decisions of the courts elsewhere
and even here.
and even here. Therefore, the decision of the judges is not necessarily bound by only the legislation in Uganda. It can also be
No doubt.
informed by the customs, the aspirations,
Very
the
good.
norms
Yes. And
of
the
the
wishes
people and the wishes of the people
of
in
Uganda.
Uganda.
Yes.
So I would want the judges in Uganda in the future and now to always also use their conscience, judicial conscience, and look at the aspirations of the people. I'm not saying that there is a quantitative way
Of finding out.
finding out
Very
those
good.
ones, but the argument I'm making is to say that the judges can only interpret the law as made in parliament. I take exception to that they
No,
can
no, no,
use
no,
that
no.
one,
No, no, no,
but
no,
they can use the doctrines of
No, no,
law,
no, no,
the
no,
principles
no,
of
no,
law,
no.
the norms of the people, the aspirations of the people, and they can also use their conscience.
If I may, nobody said that judges only interpret the law that is made in parliament.
You said
What I said is that the judges can never be a constituent assembly in permanent session. The judges can never be an upper chamber of parliament.
That was part of the
That
ruling.
that is
Justice
what-
Tebatema, when
that-
he said Parliament could not
That-
rewrite
that is
the
what.
Constitution.
Yes, that is what I was saying. That the judges, the position of the judges is they are not that. When it comes to common law, the law provides. In fact, it provides a hierarchy. They start with the constitution, they go to acts of parliament, they have regulations, they have common law, they have doctrines of equity. There's a hierarchy in the Judicature Act on how the judges
what I
should
see,
rule.
what I see, this was the Supreme Court. They have made their ruling. It is final.
Yes.
So I think we shouldn't even.
And it's the law.
and it's the law.
No,
but what is
and
likely
it
to be?
It is the
Yes.
correct
Yes.
interpretation
Yes.
of the law.
Moderator, don't make a statement.
And we shouldn't really litigate it.
No, wait,
No,
wait,
I'm
wait,
saying
wait.
because
Don't
I want to
make
take
a
the
statement.
argument to another level now.
Don't
Because this one.
Don't use that statement to almost say that we should not discuss this issue.
Ugandans
that's not what I'm
can
saying.
again
I'm
amend
saying-
the
I'm
Constitution.
saying, I'm
and
saying
we
Once it has just
there's no
been
other
amended,
court you can
they
go
can
to
amend it again.
to seek redress here.
What's wrong with that?
That is
Even amending it
that is
before,
the
what is wrong with
technical
that?
ego.
Yes.
But we can talk so that we shape the future. We are now discussing this one in order to shape the future, and we should not be discouraged from talking about this one because the judgment has been made, because we want to see the future that is in the right direction and is accountable
But-
to the population.
the future can come,
popular
I suppose.
justice, we need to understand that the role of the judges to interpret the law as it stands fairly, not as it's the fair standing of the law, not the fair standing of
Constitutional
not,
justice.
not the fair standing of public opinion. If judges were to operate following public opinion, to say that now this is what the public wants, the law says this, but the public says that, then the judges would be operating the judicial system of Pontius Pilate. This man is innocent. But the people have said what?
Now you are-
No,
Crucify him.
Welcome to
Crucify
the Bible,
him.
mister. Not that he said he was
That
not
is the
going
Holy Week. That is the Holy Week for you.
By the way, the rating,
That is the Holy Week for you. The letter is calling for Barabbas.
the betrayal was on Thursday for your information.
Yes.
At night like now.
Yes,
Well,
Last Supper.
well, actually, at around this time, the crowd was getting ready for popular justice, for Barabbas. The judges should follow what is in the law,
Sarah,
not what is
so
public
Sarah, for those who are
opinion.
opposed,
Yes.
what can they do to have their popular justice 2021?
Vote.
2021.
Because I
If
think
we-
that's
if
the
we-
other way how you can maybe change things and perhaps
Someone
I-
says it's
I
impossible
know.
to change things, that they shouldn't even vote.
No. I'm not saying that. I am
That's what
saying
I'm
the law professors have gone to Supreme Court to challenge the inaction of Attorney General on their own recommendations, time lapsed in August last year.
And
Ti-
you trust the
time
Supreme
given
Court.
to-
You trust the
to-
Supreme Court in that matter.
Why are you a heckler today? So let me
I'm following,
first submit.
I'm following the example of
No,
my
no,
senior
no.
colleague.
one at a time.
But you trust the Supreme Court?
One at a time, Alison.
So they are challenging the failure of the Attorney General to enact electoral reforms. I know in the
Will the court
last
fear
few
the
weeks, the Minister of Justice and Constitutional Affairs went to Parliament and said this country cannot raise 13 billion required to enact electoral reforms. Just after we had approved a guarantee, which is more or less in a cash form, by promissory notes to an investor that came to Uganda waving a concept with no money, with no land, with we said we can find 1.3 trillion, but we cannot find 13 billion to enact electoral reforms, which I find really disturbing. So if we can enact free and fair electoral reforms, yes, the people can determine who governs them. Their free will can be expressed and quantified.
So minus
But
electoral reforms.
given in the absence of reforms, we shall have a repeat of what happened in 2016.
So people shouldn't
Kampala and
participate.
Waxo were denied
So people
to
shouldn't
vote.
participate.
We saw fire burning countrywide. We saw the failure of the biometric system. By the way, part of the recommendations of Supreme Court is that biometric system was used without a law backing it. And one of the recommendations is to have a law backing the use of the voter biometric system. So even I'm wondering, as government intentionally refuses to enact the directives of the Supreme Court, are they going to use this system or they are going to put it to waste, since we don't have a law backing it?
What Sarah is actually saying that even in 2021 we are done. It's still
They
I
should
must
give up
say-
and not vote.
I must say here that all these things we are talking about, the issues of the day are not going to be resolved in the law courts.
Thank you.
The issues of the day are political.
Thank you.
And the politics
And they shouldn't also be resolved.
and Parliament has been abused. Parliament has been abused in Uganda, and something must be done to stop Parliament abusing its powers.
this is why
And
he
being-
doesn't give you thanks.
and being, and being
This is
used
why you don't give him thanks.
and being used by the executive.
Let me thank you
Let
at
me
my
give you-
discretion.
And an elitist group.
Let me give you the history, a short history here.
I will
Brief
also give you history. Yes.
Yes.
Yeah.
In 1966, Parliament was instrumentalized, was weaponized by the executive. And they passed,
The
they
Republican
abrogated
Constitution.
the old constitution, passed another one without even reading through. A member of Parliament would stand up and say, even if I have not read it, I support it. That was Parliament in 1986. 66. In 1987, the same Parliament, some people think the Pigeonhole Constitution is in 1966. No, it is in 1967. It is in 1966. Now, in 1967, a draft constitution was put before Parliament, and the Parliament extended itself in office for another 5 years without going back to the people. In 1967, that was
I
abusing
can thank him.
Parliament. Today, or just last year or 2017, this same Parliament
It's a different one.
seated in the same building sat and extended itself in office if it was not the Constitutional Court to quash it.
And the Supreme
They
Court.
were extending themselves again in office.
And the Supreme Court.
I think Ugandans should get annoyed with Parliament and say, stop
And happy
abusing your
I'm happy with the court.
Yeah,
Can
we're
I
going to take a break, Alson.
Okay.
We're going to take a break, Alson, and when we come back,
I want to respond. When you come back, I want to respond
Yes,
to that
you will.
constitutional history.
When we come back, I'll open the line so that the people of Uganda, those who are watching and those who try to
stupidity.
can manage to link to us, can call. You see the numbers on the screen and tell us what you think about this verdict. We'll be right back. Welcome back. You're watching On the Spot. My name is Patrick Amara. My guests tonight are Sarah Birete, Mwambutsa Ndebesa, and Elson Karhanga. I'll be coming to you so that you can also be part of this discussion. You can see the numbers on your screen. Please call us and be precise and concise. Ask a question you'll be having, or give us any submission that perhaps can be of value to our discussion. I'm taking the very first call online. Hello.
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 Yes.
Good evening, sir.
Good evening. I want to participate.
All right, you're on air, and the floor is yours right now.
Thank you.
You're
Thank
welcome.
you. Yes, this is Professor Kabwejiri again.
Yes,
joining you.
Yes, Professor Kabwejiri.
Thank you. Thank you very much. I want to ask a question to Professor Mwambutsa and Sarah Birete. Can they convince the viewers that they are the standard judges of the conscience of Uganda? Or put it another way, can they prove that the opposition represents the conscience of Uganda? Because the way they are talking, nobody else is right except the opposition and except those two, because they don't see what could be right. Who judges contrary to their views? And finally, Mr. Historian, if you are a historian as you are, how do you get over issues in society that seem to repeat themselves? What explanation do you have that we seem to go back again and again? Is it because in 66 there was Obote? Is Obote now and Museveni the same? Or is the repetition a repetition of conditions?
Okay, I think Professor Tassis. Okay, thank you very much, Professor Tassis Kabwejiri there, and I'm sure Sarah and Mr. Mwambutsa have heard your questions. They'll be able to respond to you shortly. Let me take another caller online. Hello.
Hello.
Good evening.
Good evening, Pastor Kamara. How are you, sir?
I'm fine, thank you. What's your name and where are you calling from?
Okay, I'm called Richard. Now, for myself, I think I'm happy about the ruling.
Okay.
Because it has exposed the rotten judiciary we have in Uganda, and it has exposed to the whole world that Ugandans have tried their best to try and change the government in a conducive manner, but that has not come to happen. And another thing is, this government is planning to deprive us, the people, of our rights to vote in the adult suffrage system, into the parliamentary system. That's the last nail which is going to be put in the coffin. Other than that, the people of Uganda should rise up, just like the people of Sudan did. Let's not stand, let's not sleep. We have to take on the regime. Good enough, Kamara, you introduced Mr. Museveni. You did it yourself, and he said beyond 75 years, no, someone is old retire. And you put it to him, will you come after 75? He said no. After 75 years, I will be done.
So I still think maybe he's not coming back.
The Supreme Court of Uganda, it's not the court which has sat today.
All
the
right.
Supreme Court of Uganda are us Ugandans, the people. We have to, just like the Constitution gives us the power, it says that power belongs to the people. We are the final Supreme Court which has to save ourselves, which has to save our country.
All right.
So for God and my country,
Richard, thank you very much.
I think Ugandans, it's better that we wake up and chase out the dictatorship.
You have made your point, sir. Thank you very much. You have made your point, sir. Thank you very much. And so let me just maybe take two more so that my panelists here could respond. I have another call online. Hello. All right, I think. Please. Yes, good evening, sir. What's your name and where are you calling from?
Noah Manyaruna, I'm calling from Kiruhura.
Kiruhura, you're on air.
My name is Noah Manyaruna, I'm calling from Kiruhura.
Yes, go right ahead, sir.
Yes, now there are three members there. Yourself first as a moderator, but Mr. Karhanga is an interpreter of the law. Professor Mwangusia and Madam Sarah are the givers of history of the law. Therefore, it is very important for us to really listen to how the lawyers or those that studied law interpret it. But the gentlemen who are supposed to give the history of the law, how it has acted in Uganda, if they choose to interpret, then they are doing what they are not supposed to do. So what is important for them is to really give a balance of the interpretation and and how the history.
And all right, but you have made your point, I suppose. So just maybe take the last call online.
Hello.
Hello.
Arafat Nasuru.
Nasur.
Yeah.
Where are you calling
from? Masana.
All right, you're on air, sir.
What I think, I'm calling from Masana. What I think, we should do what we are supposed to do, because this is our country. We, Ugandan, we have to be at least to keep ourselves on law, not interpreting the Constitution as we want. We have to interpret the Constitution as the law says. So what I think, we have to keep the Constitution as it is.
Yeah, but it's the same constitution that has been, some people would say, mutilated beyond recognition.
I agree with you.
All right, my producer is telling me I can take one more. I understand many people online and you want to contribute. Perhaps this is something that's so dear to you. I have another call online.
Hello?
Good evening, sir.
Good evening, Patrick. How are you today?
I'm fine, thank you. What's your name and where are you calling from?
Derek is my name, calling in from Entebbe.
Okay, you're on air, Derek.
Yeah, I'd like to appreciate the judges. It was such an instrumental judgment. Hello?
Yes.
Yes, I think we need to appreciate the judges. They interpreted the law. So I'm not in agreement with the opposition because they think that their ideas are always the best. They should also know that the silent majority are so interested in the government.
Okay.
Yes, and we should work together for the success of Uganda.
Okay, thank you very much. All right, I unfortunately can't take in more of your calls. At least that's a sample we've had for tonight, and we respect your views. Okay, our time is going to be out, so I'll be giving you time to respond to the questions, but also you make your concluding remark. Let me begin with you, Professor Mwambutsa.
Oh, thank you. Beginning with Professor Kabwejere, I do agree with Professor Kabwejere that there is no objective way of determining the conscience and consciousness of the people and the position of the people in Uganda. And even in my submissions, I have not faulted even the judges about that. I was only arguing that when the judges are making judgment, do they also consider the aspirations of the people? Maybe they did. I don't know. Maybe they did, maybe they didn't do. And I was also saying that isn't there such a thing like judicial consciousness, that you have your conscience. And I was commenting on it in respect of a young nation like Uganda, a young country actually, which is not yet a nation, that when you are making a judgment, do you consider the effect of that judgment? I heard them talk about the effect of the judgment, the fatal effect of the judgment on constitutionality or whatever, but I would also want to put it to them and others who might be like them. Do they consider the effect of their judgment on nation building? That is what I was saying. As for the history repeating itself, if you want, that what happened in 66 and 67 is happening now, and why is it happening? Yes, I know that certain objective conditions that pertain in 66 are still here. But society does not move only on objective conditions. You could have subjective conditions which can also change the objective conditions. And I am therefore saying that 40 years, 50 years down the road, can we put in place through civic consciousness, civic awareness, civicness, can we put in place a situation which can alter this consciousness, the subjective conditions that can alter the consciousness, so that we have got accountable governments, accountable judiciary, accountable parliament, where the citizens become citizens and they stop being subjects and leave things to be done by the others. So that is what I was saying. But otherwise, I agree with the professor that there is no objective way of determining the consciousness of the people, the conscience of the people, but the judges who have made their judgments today, whichever way they have made the conscience, the judgment, the way they have made it, it is up to them, and they have used the law, and they can go with their heads up in the public. Let them tomorrow drive in Kampala, we shall wave to them.
What is that supposed to mean?
What it means is, I'm saying,
even you shall wave at you.
Yeah, we shall wave at me. We shall wave at the judges the way they have.
All right, I don't want to go there. Mr. Ellison Karanga, sorry, you're parting short because it looks like you didn't have a question, but you can give us your concluding remark.
I had the overwhelming support of the callers. Yeah. No, you see, the judges gave their decision today based on the tools that are available to the judges. To ask them to use other tools is to ask them to to change the field, to change the arena, is to ask them to become players and not umpires. But what I want to say really in conclusion, because we can have this constitutional discussion, consciousness discussion, electoral reforms discussion, and root it in history for the foreseeable future. The big challenge I have with the electoral reform brigade of Sarah, for example, is that almost every election in Uganda has represented some form of electoral reform. But when we got independence in 1962, and I can be corrected because we have an expert in history, we didn't have we had an election before independence. The first election we had after independence was the election in 1980. That was the first election of independent Uganda. That election was not a direct election. We were voting for members of parliament who would then choose who leads the country.
No, but members of parliament were voted directly.
Directly. Members of parliament were voted directly, but there was no direct election of a president. The very first time, let me finish. The very first time Ugandans directly voted for a president, which also represented electoral reform, was in 1996. The very first time Ugandans had an election 5 years after the previous election was in 2001. The very first time Ugandans voted for a president under a multi-party system directly was in 2006, from 1962. The first multi-party presidential election in Uganda was in 2006. The very first time we had an election where there was no first time was 2011. The point I'm making is that the politics of electoral reform has been in this country since this country was born in 1962. People say we need to reboot. We need to have a national conference. We need to have this big dialogue. We need to change this. And the politics of electoral reform remains in the societies that remain in the permanent politics of electoral reform. Maybe the thing we need to do is to realize what the challenges of this country are and address the challenges of this country, not remain in a permanent state of reforming elections.
So you have given a history that they have always been a reformer almost at every election.
Every election,
so even
every
yeah,
election
yes,
is a precedent.
Yes. But even now, Sarah is telling you we still need reforms.
Yes.
In fact, using your argument,
I'm saying every election is a precedent. I'm not saying we shouldn't reform our electoral system.
No.
Countries like
you emphasize her point.
Countries like the United Kingdom,
for
example, held a referendum on the voting system that they use, first past the post or proportional,
Alison,
in 1960s. The point I'm making, though, is that these sort of debates about reforms of elections, about the type of elections, about the type of system, are not the sort of debates you can have within the confines of a judicial system. And to expect the judges to do that, to expect the judges to sit there and then become the Constituent Assembly in permanent session.
But they're the ones who made those recommendations. Sarah, you're parting short. Yes.
It's amazing how Elson is arguing.
Very well.
And maybe you should be reminded.
Let us have one at a time.
You should be reminded that he was counsel for Electoral Commission in the very petition where Supreme Court gave a directive to Attorney General. He was representing Electoral Commission. True or false? In the last petition, no, let me give my parting shot. So it's amazing that he was a party to that. No, yes. But he's saying now the electoral reforms of the Sarah's brigade. Yet he was there.
I have no problem with reforms. I'm just telling you. Okay, sorry.
Yeah, so but my parting shot.
I
will use the concluding sentence in the preamble that the 1995 Constitution was made and the framers said they had put an order for prosperity of Ugandans and for posterity. But if you look at things that are happening, and maybe my message to Ugandans, and maybe a message of hope, is that nobody can change the truth. People can only adjust to the truth. The truth is out there. Nobody can change the truth.
I hope you can adjust to it.
Nobody can change the truth.
But truth is relative, it can be changed.
No, what I'm saying is...
she shall adjust.
Can we let her make her parting shot?
Your time, yes. The truth is out there. The Ugandans who opposed this amendment are there. Those who went to court are there. The different constitutional judgments are there. The dissenting side increased from 1 to 3, which is good. And Ugandans will restore constitutionalism in this country.
Thank you very much. Alson Karuhanga, Mwambutsa Ntebesa, and Sarah Bireti, and all of you for being part of this.
I don't know if the last is a threat.
And well, if you don't agree with all these, at least you are going to have your say when it comes to 2021. Probably you can vote otherwise or emphasize what has just been ruled now, the verdict. It is your duty to do that.
The court has given you back your power.
It's your duty to do that. But the most important thing is that let us discuss all these things with civility, because we're all part of this country called Uganda, and we have no any other Uganda but only this one. Good night, and God bless Uganda, and enjoy your Easter. Happy Easter holiday.
Thank you.